Your contract says governed by Indian law and courts in Gujarat, but the arbitration clause quietly send you to Bogota, Colombia. So who has power, Indian courts or a foreign seat? DeSortho, a Colombian company, signed an exclusive distributor agreement with Indian medical device maker Merrill in 2016. Clause 16.5 says this agreement is governed by Indian law and the dispute shall go to the Gujarat courts. But the same did not happen. When disputes arose, DeSorto came to Supreme Court of India under Section 11(6) of Arbitration and Conciliation Act, asking it to appoint arbitral tribunal in India. The question was sharp. If the contract is governed by Indian law and mentions Indian courts, can Indian courts still appoint arbitrators under 11(6) when arbitration seat is fixed abroad, which was there in Bogota? The Supreme Court broke it down to three different systems of law: lex contractus, the governing of the substantive contract, the lex arbitrary, and thirdly, lex fori, the law of court that supervises the arbitration. Relying to this three-stage test, the Supreme Court enhanced the ambit of the act. The court said yes, the distributor agreement is governed by Indian law and Gujarat courts for substantive disputes, that the lex contractus. But clause 18 clearly sends arbitration to Bogota under Colombian procedural law, making Colombia the jurisdictional seat for this particular case. So Indian courts simply had no jurisdiction to appoint arbitrators here. The Section 11 petition was dismissed. The key takeaway here is that Indian governing law in your contract does not automatically mean Indian courts for arbitration. The seat clause wins, and that one word can shift entire supervisory power out of India. So always remember this while drafting arbitration agreements.